Welcome to the Screening Without Borders Top Travel Tips for Background Data conference call. We have just a few announcements before we begin. The slides will advance automatically throughout the presentation. To enlarge the slides, click the Enlarge Slides button located above your presentation window. Should you need technical assistance, click on the Help button. If your screen freezes or the slides do not appear to be advancing as they should, please try exiting and restarting the session, as it may be an issue with your connectivity. At any time, you can submit a question using the Ask a Question box located in the bottom of your screen. I'd now like to turn the call over to Shari Hubbard. Shari, please go ahead.
Yes. Hello, everyone, and welcome to the webinar. I have a couple of items to go over with you. I manage our webinar productions here at First Advantage. So first of all, if you would like continuing education credit hours for this session, I need you to stay on the entire time. Secondly, you will get a copy of the PowerPoint slides in PDF form. They'll be emailed to you after the event, but you also have access to those via your console. If you look for those PDFs, it will be there in your tools. And finally, I am pleased to introduce our speakers today. So we have Joe Kenny with us, who is our Senior Vice President and Chief Global Compliance Officer here at First Advantage. And we also have Matt Clark, who is our Senior Vice President of Global Clients. Both have extensive experience with helping clients with these topics. In addition, we have Anjali Haney, who is with us today, who will be managing our questions that are submitted, and you'll see a Q&A tab. You can submit questions throughout the event, and we'll take those as many as we can at the end of the event and answer them, and Anjali will be watching that queue. She is our Senior Attorney and Regional Compliance Officer for EMEA and Dubai. So without further ado, I'd like to turn the time over to Joe.
Thank you so much, Shari. And thank you all for joining us, for joining Matt and I, where I'm giving us the opportunity to review Screening Without Borders. Here's our disclaimer. We all have them as lawyers. The agenda for today will include global screening best practices, some implementation suggestions, conversation about country data localization laws, global data privacy, and the General Data Protection Regulation, or affectionately known as GDPR. We'll also share some benchmarking learnings that we have as a screening or global screening organization with you today. So we'll start with global screening practices. So as far as global screening practices generally, I think the first important comment that I need to share with you is that global screening is not just about criminal background screening. It's really about other checks as well. For example, employment, education verifications, right to work where they're available, sanctions checks. And for those of you who do sanction checks, you know there's a very large scope around sanction checks. So there's a very long list of various checks available for an employer depending on their organizational needs and the permissibility of certain checks and availability of certain checks in different countries. And that does bring us to the comment about country laws. I mean, country laws are regularly changing. They require ongoing monitoring, and generally speaking, that's an ongoing tracking experience and extravaganza, if you will. And First Advantage Global Compliance does that along with our regional compliance officers and our local compliance officers, and also with the support of our suppliers that we might be sourcing some of the screening that we're doing. We also have to consider trends towards data localization, nationalization, and also sovereignty issues. And, of course, I'm speaking about Russia and China. And I'm sure I doubt very much there's anyone on this call that is not familiar with the term data localization, where the data has to stay in a particular country. There's also trends towards data protection all over the world, particularly with respect to personal and sensitive identification data China. We had a challenge with Korea a couple of years ago. And, of course, special procedures and forms may be required in particular countries, and that needs to be kept into consideration or taken into consideration. The business models also vary relative to global screening based on the commentary on this particular slide, which I'm not going to read to you, but just to say that it really depends on what the organization's needs are and where, what particular global screening needs they have depending on their own organization. Matt, would you like to comment at all on the business models that we're seeing from a practical point of view?
Sure, Joe, that's fine. So most of the models we see are where organizations have a clear structure in the relation to the way that they roll out their programs, i.e. they have a hierarchy where it says this is the global lead, and from there they have regional leads, and they also may have in-country leads from there. I'm going to be talking about that a bit later on in the webinar, but those are the programs that we find that run most successfully as opposed to ones where they have a more delineated approach to the screening program.
We also see some common customer characteristics, and thank you, Matt, for those comments. And we see large decentralized or we see localized human resource organizations, and that can have an impact on the way a global screening program would work. We also have corporate security and screening requirements versus local cultures and infrastructure concerns. We have, of course, as I mentioned already, local legal and compliance requirements that need to be considered country by country. There's a need for change management associated with global background screening, with borderless screening, and that change management approach is very, very important to a successful program. And included in that might be a phased rollout for an organization that's just starting to globalize its program, and also ensuring that there is a significant support model in place. So let's talk about what we might have at First Advantage regarding implementation suggestions. So first of all, when we think about a global screening program, I would say that the first and most critical piece and foundation of a global screening program is the analysis of the particular organization's needs. From there, a policy can be crafted that's specific to the organization, and along with that, a process that makes sense for the organization, probably with some nuances from country to country. And then the design of that program, how would the program actually work from an operational point of view? And I'm talking about packages and approaches depending on country-specific requirements. And probably Matt will speak to that a little bit more because he gets more into that than I do. And then, of course, it's a go. And once you go, meaning implement the program, you really need to review that program and audit that program. To ensure that it is specifically, if it's working, is it working the way an organization wants? Again, we have to look to that organizational structure when we're thinking about this program, whether it's centralized or decentralized. And let's not forget those key stakeholders. They're very, very important in this process because you need their support throughout the screening program. So we're thinking about people, we're thinking about processes, we're thinking about technology. And the key countries have to be focused on as well, starting probably with the high-risk countries first, and take the challenge at the front end, with the current projected hiring being a consideration and the types of candidates or applicants or data subjects, their profiles that you're seeking to get information on from a background screening perspective. Matt, do you have any comments on that from a practical day-to-day approach?
Sure. So policies normally are run centrally at most organizations, so the legal part of the organization may have done a review of the market and say, For example, we've found in this country here, this approach should now be taken, and as such, a policy will be created by the organization, and that could be on our side or their side or the customer side, and then that is flowed down into the business, and then that policy, if it has an effect on the screening program, then needs to be implemented into the screening program, and maybe changes made accordingly. That may mean that checks that you're running need to stop running, or maybe there are regulated checks that need to come in because of policy changes.
Thank you, Matt. And we actually highlighted that on this slide on policy development, that all-important intelligence gathering as the foundation step, and then that review and feedback and that organizational buy-in, the importance of communication and collaboration, and also notification just before intent to launch, because sometimes folks have maybe a short-term memory of change, and they have to be reminded. So that brings us, of course, to process understanding, understanding by country, by the business or unit group, screening process in context, and relationship to other processes as well, including, so that's great. You get a report, a screening report. What do you do with it? I mean, so now we're talking about adverse action. We're talking about a decision not to hire and all of the policy implications with respect to that, with offer letters, all of those pieces. And, of course, preceding that is the whole issue of requisition and the recruitment process. So process understanding, very important. And that leads, of course, to the design of the program, understanding what changes are necessary to make this Screening Without Borders program work, this global program, again, stressing people, process, and technology. Who's going to be affected? And you're going to get some naysayers. It's unusual for change not to bring a few naysayers, and then again, that's a matter of communication and collaboration, which is why First Advantage has a change management toolkit that we usually share when we're onboarding a global client to help them overcome some of these challenges, if you will, and they are very much, we're very much able to overcome them as an organization and in supporting you. But again, the critical role of communication should not be minimized. The notice of intent to change, the benefits of change, and of course the risks. I mean, we have to sell all messages as organizational leaders, and this is not exempt from that particular need. So we also have, again, that policy that Matt was referring to. And when we're talking about the policy, how does that work from a practical point of view? Well, that's when you talk about service flexibility, the packages, how they're going to be rolled out, what does the organization really need, what should their program actually look like, country by country, setting up the users and the accounts, and also, of course, timelines and a phased approach possibly. Matt, do you have any additional comments on the design around these issues for the packages, et cetera?
Yeah, no, I would say that most packages should be kept as simple as possible, as in the number of packages that are run is kept to a minimum. We often find programs where they have multiple packages running. The complexity of running those packages, or even the differences between those different packages, becomes indiscernible. But what it does mean that it creates more administration work in the management of those packages. So with most global screening programs, we would really ask companies to look at the packages they run and the number of packages they run and try and keep those to a bare minimum.
Thank you, Matt. So we're now at GO, meaning setup and training. Training, always very important. Training on the system, training on the process requirements, and ongoing change management oversight and communication. And, of course, now we're talking about the account hierarchy that Matt is alluding to, reviewing and the ordering permissions and all of the management of adjudication, like I mentioned, your own guidelines as an organization, your reporting expectations, and, of course, billing. Billing's an important part of this as well, getting that right so that doesn't create a distraction for a global or really any employer. More on going is the knowledge transfer and training the trainer. It's fine that you start with some initial training, but that training has to flow down. Flow down is very important. Ordering and reporting, initial tracking and turnaround time, and the user experience, really the customer experience, really critical in all of this to make sure that that experience of the end user is a positive one, is a comfortable one. And then and issue tracking, if there's questions that are coming up frequently, a way to manage those questions and ensure that those questions are answered in advance, if at all possible, if they become a trend, if you will. And always you're wanting to review, you're wanting to audit, and you're wanting to improve your global program. And you do that with lessons learned by reviewing and revision, going back to that audit commentary. Account maintenance. I mean, you can't just set up a package or group of packages country by country and going to consider that they're going to work forever. They may not. The supplier might change, the law might change, the needs of the organization might change. So that's really an ongoing exercise. Services, turnaround time, there may become an issue with turnaround time in a particular country for whatever reason, and that needs to be addressed. And that's why that periodic review with internal user feedback is so important, why a process review is important, ongoing, and why business needs are always needing to be considered, which is why, again, communication with the business leaders that are managing the program. I mean, often we approach that, Matt and I, with calls, or Anjali as well, with particular clients who, want to review changes in legislation, changes in country law, changes in process. I don't know, Matt, if you want to, comment on that piece of it, which is really very, very important in the ongoing maintenance of a program, of a global program. In fact, that segues to your suggestions, Matt, for a successful program.
Thank you, Jo.
I cede the floor.
Thank you. So I want to just talk through some of the things that we've seen in our experience over the last few years that have helped to ensure that organizations run a successful screening program under what is, when you're working at a global level, difficult conditions. So the first thing I want to pick up on is standardizing the way that you screen around the world. So a lot of organizations will work and screen globally, but what they don't do is say there's want to be a standard way to how we work in every single country and region. And that's okay. There's not a right way or a wrong way, but we've found that though the effort to set up a standardized screening program can be harder, once it's in place, that screening program runs more efficiently and is easier to manage in the long run. And the way that we find that's done is to set up a group of packages, and that may range from, say, 7 to, say, maybe 20 packages that cover all the types of roles that an organization has. And in those packages, they're made up of a collection of checks, and those checks are run on all worker types in that area. So if it's a standard type of worker, for example, it may be made up of about 5 different packages, 5 different checks, and those checks are run on all worker types that meet that criteria all around the world. And the way that the system works is it has an inbuilt compliance engine inside it, so that when you run a package on, say, somebody in Hong Kong, where you can't run certain checks in Hong Kong due to legal restrictions, it won't run those checks on the person who's sat in Hong Kong, but it will run those checks on people who are sat outside of Hong Kong or maybe experience they've had outside of Hong Kong. So the system itself will control what checks are actually ran in those packages based on the location of where those checks are being run. Where this is the case, we can also add new packages into the system, and we can remove packages that are no longer required. So if a new law changes, or maybe a new worker type comes up in an organization, or maybe a company buys another sort of business and it needs a new type of package for that business, a new package can be set up with a standard set of checks, and those checks then ran on those workers. Again, the inbuilt compliance engine in the system will control which checks are run and which checks aren't run based on the location of where those checks need to be run. New checks can be added into those packages as well, so that as laws change and availability becomes of new checks come online, so those new checks can be added into the package, and it just means that one check needs to be added into one package, and then that will be run globally for every worker type. It doesn't require multiple packages to be updated for all different countries just because one new check is required. Obviously, keeping this in track in multiple countries around the world can be quite difficult. And the way that we find that works best of all is that where there's a clean governance structure set up both within the customer organization and also within the FADB organization to manage the customer business. And that would have a global lead on both sides and then regional leads around the globe. And then under that may also sit in-country leads. And those in-country leads and those regional leads face off with each other, and so they can make a decision locally to manage the business locally, but what they can't do is create new packages and add new checks in without sign-off by the global leads on both sides to ensure that the global screening program always runs consistently. A further step to help with this is that good management information that gives you an insight into your global program is essential. So you want to be able to see what is successfully running in your organization in relation to screening, but also what isn't running so well. Is there a particular package you're running or a particular type of check you're running in a certain country that is perhaps causing you issues? And by having that insight, you can drill down from a package level to a country level, right down to an individual level to find out what is being successful and what is not working successfully, and then take steps to adjust your screening program accordingly to ensure it's always running at its optimum. Joe, I'm going to hand back to you now for the information availability. Thank you.
Joe, you may be on mute. I'm not hearing you.
Hi, it's Joe again. Thank you, Matt, for handing it over to me. Before I move on to the country data localization laws, the global data privacy and GDPR, I want to briefly speak about information availability. Information availability is absolutely the biggest challenge when an organization decides to add new screening service capability on a global basis, and even in the U.S. So really, data suppliers make information and data available for a variety of purposes, and we do use suppliers. Every background screening pretty much does. But what we have to be aware of is that there are some checks that even though they may be available are not advisable to use due to compliance considerations. So First Advantage independently researches whether or not available data may be used in an employment or residential screening context, and we also rely on our suppliers to a certain extent and certainly to outside counsel. And Anjali and I and our regional compliance officers, our global compliance team, works very hard to make sure that we're not doing checks that are not permitted. And by the way, we might be at odds with another organization that would feel more comfortable offering a certain check. But we take a conservative position, and we really want to make sure that what we offer is indeed compliant with various country law. The other piece is, of course, consents. You hear about consents all the time, and one of the big things that we hear about always is the electronic versus the written signature. And there's certainly a user demand from a convenience point of view, and certainly for everybody it's more convenient to be able to do an electronic sign-off. But in some countries that is just not permitted, and wet signatures are required. And there's regulatory interpretations and associated enforcement that can sometimes be unclear and can evolve very quickly. So really this is a challenge for all of us on the consent side, but certainly where electronic signatures are permitted, that certainly makes the program work a lot more smoothly. So let us kind of segue now into country data localization laws, global data privacy, and the GDPR. So about data privacy, again, we're going back to the data localization laws. We're talking about cross-border data privacy. We're talking about those privacy laws in the various countries. We're talking about mapping the process, what data, where data can flow, where it should flow, what impacts the data privacy laws have on that flow. And, of course, the general data protection regulation that has been a very big part of many of our lives over the last 2 years, and now is in the implementation phase as of June. So about these country data localization laws, in countries where you do indeed have these laws, personal data has to stay within that country. But when I say that, I have to say it's subject to conditions or parameters. That's the sticking point, finding out what those conditions are and what the parameters are regarding staying in the country. So, for example, a transfer can occur in some countries only after meeting certain requirements, and Russia is a good example where the data has to first be stored within that country and before it can be transferred out. So the supplier relationship, the vendor management, vendor relationship becomes very important for a screening company like First Advantage in support of our client. We want to be sure that we're not moving data where it shouldn't be moved and somehow running afoul of the expectations regarding these data localizations law. And they have to really be considered in the practical implementation of our clients' programs. Now, turning to cross-border data privacy, typically cross-border data privacy laws either forbid cross-border transfers unless certain conditions are met, as I just said, but the focus is on ensuring what data remains is protected no matter where it's sent. So the definition of privacy in a particular country can vary. For example, the definition of privacy in India may differ from a definition of privacy in the U.S., which is why we do local country training for our team members so they understand the nuances in the definition of privacy and the definition of PII, protected identification, identifying information. It varies. And understand the roles of the controller, that's our client, the one who actually has the use of the data, and the processor who's actually providing the data, like First Advantage. And this whole thing about mapping the data flows to check for compliance is a really critical part of that. Now, First Advantage, like every organization that's supporting the GDPR, has a data protection officer, and ours happens to be a privacy expert with the necessary designations to support his skill set and expertise. And so our data protection officer, Ian Burnett, will monitor those pieces and ensure that we are indeed mapping the flows along with our information technology team, our information security team, and that we are keeping in compliance with the requirements for cross-border data transfer. So let's turn a little bit more now to GDPR highlights. We have about 15 minutes before question time and any other kind of deep dive we might want to do on the subject matter of this discussion. So GDPR highlights, as far as consent requirements, those were expanded with GDPR. Consent cannot be implied. It has to be withdrawn in an easy way for the data subject. And the data subject has a right to be forgotten. That right to be forgotten was expanded under GDPR, and there's a data deletion aspect of it that needs very careful scrutiny as well. Data minimization was an existing concept before GDPR, but it is also included in GDPR. And then there were some key changes in the General Data Protection Regulation regarding agreements with processors with a company like First Advantage. I want to make a bold statement here that First Advantage, a global employment background screening provider, is indeed in compliance with all the rules and regulations and the provisions of its services, and it will continue to be in compliance with all laws and regulations, including the new GDPR, which was implemented now way back May 25th of 2018 regarding our support as a processor. And again, those roles are important. So I keep talking about data controller versus data processor. Well, this is a key concept in GDPR, is whether the business is a data controller or a data processor. In some cases, a business can be both. It just depends on the aspect of the business that's being considered. But in our background screening business at First Advantage, we consider our client the data controller. It's the data's going to you and you're deciding what to do with it. And we're processing the data and giving it to you so that you can support your program as you so choose. Which, of course, brings us to the all-important privacy notice. And this was and continues to be a subject of much discussion regarding notice and consent. And some nuances evolved from GDPR regarding notice and consent, and all of us have consulted our outside counsel for the most part and looked at our organizational needs and requirements to try to determine what that notice and consent should look like and how it should work, considering the nuances of our particular organization. For example, we may have a client who needs to add to the sample notice and consent that we provide our clients a section where they can add the appropriate and legitimate basis for the background screening if that's indicated or applicable. And essentially, the privacy notice that we provide our clients is a hybrid notice, and we combine it with a consent. So the consent is the tail wagging the dog, basically, and it starts instead with the privacy notice. And this was on the advice of our legal counsel at First Advantage. Again, it's a template to start with, a starting point for our clients. We also note that many data sources do require a consent of some sort in order to provide the information to our clients. So the consent at the end can become important from that perspective as well, which is why I don't think you can overlook consent, even if consent has become a little bit more challenging. It is a valid basis for processing personal data, but in and of itself, it may be insufficient in the employment context, and that, of course, is the crux of the discussion around consents in GDPR. And that's because a consent has to be freely given, and the question is, can consent ever be freely given in the employment context where where the data subject wants the job and or wants a position, and is that truly unfettered consent? And that, of course, is a data controller responsibility to make some of those decisions and policy decisions and around that. And they can certainly use the First Advantage platform technology to host the document, the consent or privacy. Which brings us to withdrawing consent. So what about withdrawing consent? So candidates under GDPR have to be given the right to withdraw consent as easily as if when they provided the consent. So that being said, oftentimes a common approach is to include that in the privacy notice that informs the candidate of the email address of the client, so the data subject or candidate can withdraw their consent. The candidate should contact the prospective employer as the controller and the entity that obtained the consent. Now, that being said, sometimes the candidate is actually going to contact First Advantage first as a background screener versus maybe our privacy inbox or otherwise. And then First Advantage will always contact the client first to get instructions as to how our client would want us to proceed. So moving on a little bit more on GDPR requirements, there needs to be a legitimate basis for processing, requires that both the processing and where applicable cross-border transfer the data has a lawful basis. And really, it's not, this is a really important piece of it because the consent alone is not enough. And again, I just mentioned about the freely given, refuse to revoke consent. That whole piece from the, as articulated by Article 29 of the Data Protection Working Party made this concern about consents and them being freely given very, very clear, crystal clear to all of us, which is, I think, impacted some of the samples that you're seeing out there regarding the privacy statement or notice and the consent. So again, in addition to the privacy notice which is required by GDPR and the consent, organizations really should consider other legal grounds for processing, meaning do you have a regulatory requirement in the financial services industry or some other legal grounds where applicable regarding the cross-border transfer of data, and if so, to use that as a legitimate basis for processing as well. And that whole legitimate interest seems like a very good analysis, an important analysis for any organization to make, and taking into account the nature of the personal data in question and looking at that as well. Which brings us to that right to be forgotten, and that's the right of the data subject or the candidate to request the erasure of personal information. And this isn't a new right that was created by GDPR, but it's included in GDPR. And under the current law, data subjects may have their personal information erased, and really we're talking about blocking information where a controller fails to comply with the law, especially where the data is incomplete or inaccurate. So that's a very important aspect. And of course, there's a range of circumstances that support this right to be forgotten, and each of them need to be considered in turn. For example, the data may no longer be needed for the original purpose, and no new lawful purpose exists, where the lawful basis for the processing is the data subject's consent, and the data subject did that right to be forgotten withdrawal of the consent, or the data subject exercises the right to object in a challenge and is challenging the information, or that unfortunately, let's say the data has been unlawfully processed by in error, or erasure is necessary for compliance with a European Union law or a national law of a member state. And I know that we've spoken, Anjali and I, and Anjali in particular, with all the tracking of the member states who may have their own variations of GDPR, and those are evolving as we speak even now. Which then brings us to data retention and deletion, which is an important part of the whole process. You know, you need to be able to operationalize that, and our system allows us to do that with settings regarding data retention, contractual agreements associated with that, and of course a data purging service as well, so that candidates can request their information be purged from the system, which is of course what background screening companies like First Advantage should have in place as well for candidates. And then you've got derogations and legislation regarding data retention. What we do is we looked really long and hard at our system regarding data retention, and we have a global records retention policy and a destruction process that associated with that helps us stay within the guidelines globally regarding record retention and data deletion or destruction. And of course, some of our financial services business or other businesses have a need to retain candidate data for some time, and others may have a different policy on that, such as a shorter time frame. But really, data retention is something that's owned by our clients, and they decide how long to keep their data. Which then brings us to data residency. Where should all this data reside? And that really goes back to the whole issue of data localization and cross-border. And so First Advantage has a data center in Amsterdam, state-of-the-art data center, that helps us keep data where it should be in the case of European Union data. And that particular data center is in Amsterdam. It was opened in anticipation of GDPR and to ensure that we are indeed in compliance, which then brings us to benchmarking our learnings. And this is where I'll be calling on Matt for some of the things he's been hearing. Again, I just want to say that data minimization is not a new concept at all. There was a directive prior to GDPR in 1995, and really our systems are generally set up to collect the minimum amount of information necessary to complete a background check. But we have an enhancement that allows our clients to really drill down a bit on more precise address history collection, and they can set up preferences at the package level regarding that, which we believe was an important enhancement to have in place. And there's also service agreement updates to address the processor requirements, including the sub-processors, our suppliers that have to be considered. And we have worked on those for some time now, and I would say that we're in pretty good shape with that. As far as lessons learned from all of this, before we move into questions and Matt makes any commentary he'd like to make, we believe that in the time that First Advantage has been conducting and supporting global screening for our clients, we have learned 10 good lessons. And one is the importance of our organizational client securing executive sponsorship and support, that a project organization is in place, and that a small core implementation team is empowered to develop a policy and program, to make decisions, and to take action as a global screening program is being rolled out. That a client determine their short-term and long-term global strategy and objectives to keep on focus and on track, and develop a global background screening policy. Also to develop and be prepared to make decisions around what do you do with a report, an adverse report? How do you adjudicate your particular screening reports and outcomes? Designating regional and corporate program managers, identifying stakeholders and obtaining their buy-in, and developing that all-important change management program and plan that I mentioned throughout this conversation with you all, to engage, align, and partner with users, very important, and to implement the program in phases by regions. And I know that Matt spoke a lot about packages and the organization of the program. So before we turn over to the questions and Anjali supporting us with that, Matt, would you have any closing remarks?
No, thanks, Jo. I wanted to say really that setting up a global screening program can be a daunting task. It can be difficult. You look ahead of it. I know organizations, especially these very large multinational organizations, can be very complex in the way that they run. And to put your arms around those organizations is a very difficult task. But I have to say, and I know I mentioned it earlier, but the organizations that do take the steps to say we are going to put global controls into what we do certainly have the most smooth running screening programs, and they certainly run in the most efficient way possible. And it becomes easier for both the company and also for the screening vendor to run those programs when there are clear lines and clear policies and directions as to how the screening program should run around the world. And then keeping a control on that really is just a case of policing how that screening program is running to make sure that it is staying true to its original purpose when it was set up. That doesn't mean adjustments can't be made to it, but the objective of the screening program when it was first set up should be adhered to ongoing from that point onwards. Thank you, Jo.
Thank you very much, Matt. And, the one thing I didn't mention before we go into questions is that right now, one of the cross-border authority permissions is the EU-US Privacy Shield, and I would be remiss in not mentioning that that's pretty much under attack right now, to say the least, and you'll see a lot of articles on the Internet on it, and the question being whether model clauses would be preferable if the Privacy Shield does not withstand scrutiny, similar to what happened with the Safe Harbor, and then, of course, the preferred binding corporate rules approach that's being under a consideration as a preferred way. And, of course, First Advantage is looking at all of this and trying to figure out, if Privacy Shield does not withstand scrutiny and becomes no longer a valid method for international data transfer, and Swiss Privacy Shield maybe by extension, who knows. We're going to have to really start looking at that now, and we are. So I just raised that for your general knowledge because that is one of the bases for cross-border transfer. At this point, I would then turn this session over to Anjali to start giving you a chance to ask your questions and for us to attempt to respond with information that we have available. So Anjali, please.
Thanks, Jo. So the first question that we have is about the data retention that we touched on, and the question was how long First Advantage typically would hold the data for a candidate, and what type of data is actually retained? Is it the whole report?
Certainly. I don't know if you want to answer that, but I can answer that. Basically, in the U.S., because of FCRA, and even though it's not specifically in FCRA, we will keep data for 7 years. Globally, our general parameter is 2 years, and that was after much angst to come to that conclusion. Again, we revert to the preference of the client around their process and procedure and their organizational preferences. What was the other part of the question, Anjali?
About whether the final report is retained, including CRB details. Not quite sure.
Yeah, the final report is retained. The scope of the rest of it, I believe it's some of the source data, et cetera, that we keep as well, and if there are consents, any of that piece as well.
Right. Yep. And I would agree with that. And the only thing I would add, too, is that the other thing to keep in mind is that sometimes data sources themselves will have retention requirements. So those have to be considered. So if you get your data from a criminal records provider, such as Disclosure Scotland, for example, they may have retention requirements.
Right. Yeah, that's true. So you do have to consider a little bit more regarding the data source expectations. Good point. Next question.
Another question that we have is, do you have any advice for a small company that does not regularly recruit internationally but has an occasional one-off international candidate or small project? This question might be for Matt, potentially.
Yeah, I'd like to lob that to Matt. Matt, what are your thoughts on that? It's a good question.
Could you repeat the question, sorry, Anjali?
Sure. Do you have any advice for a small company that does not regularly recruit internationally but has an occasional one-off international candidate or small project?
Sure. I would recommend setting up a package that has, well, if the package is set up to cover all the checks that organization is looking for, that package can be run both domestically and also internationally. So they may want to say, well, actually, we want to capture this as an international screening, in which case you could take the domestic package and clone it almost, and say this is now an international package and is aimed at candidates that will be coming in probably from outside our domestic region. But likewise, as I say, the system does have an inbuilt compliance engine inside it. So the same package that you would run domestically can also be run internationally, because it will only run checks that are permissible internationally regardless of the country that they're in. So you can run it in the United States, in the UK, in Hong Kong, and in Australia, the same package, but only the checks that the organization wants run will be run in line with the local legislation that allows those checks to be run, if that makes sense.
And so, to your point, Matt, I would believe that for a smaller organization at the outset, it would be important for them to let their background screening provider know that they may have occasional need for a global package, so that the packages can be set up to meet that need as that need arises.
Correct. I mean, it ultimately depends how an organization wants to track its screening. It may say we've got one package and that can run anywhere in the world, and that's regardless of the size of the organization. Or the organization may say, actually, we want to be able to determine that these types of screening were actually run specifically on people from outside our domestic region, and therefore it's a specific package that says that is targeted at candidates from an international background.
Thank you. Next question, Anjali.
So the next question is, let's see, will the compliance engine that you mentioned report back that elements are not reportable based on the search country selected? That might mean search or country selected. So I think what the question is trying to ask here is how do they know what is actually excluded? Does the engine itself not offer the search if it's not permitted or not available? I think that's what we're getting at.
Correct. So it's the engine itself is controlled by the regulations based on how we understand the laws of a particular country where that check is to be run. So the package will run the check in every country where the candidate is based over during the duration of that background screening package. And the duration of that background screening package is determined by the organization. Some companies have 5 years, some companies have 7 years, some companies have 10 years. So wherever that candidate has resided during the period of the time that background package duration, the checks will run in those countries, but the checks won't run if it's not permissible to do it. For example, if you can't do a criminal check in Hong Kong, but you can in the United States, it will run the criminal check in the United States, but not in Hong Kong. As part of many vendors, what they will provide to their customers is a compliance booklet, which basically says, for these countries, these are the checks which are permissible to run. And so if there's any doubt by the customer, they can look at those reference guides to find out which checks are permissible to run in those countries. But otherwise, I guess it's a case of trusting the system to say the system has run all the checks that are permissible to run under that package in the locations required.
And I would add that that information is actually provided to the information technology team, and that's to support that particular, can you not, is the global and legal compliance team. And so we would be tracking and watching and also working with our suppliers, and if a check suddenly becomes at issue in a particular country or some nuance has evolved, the compliance engine would be updated and corrected to make sure that we don't run afoul of a country law. And that happens in the U.S. as well, of course. Anjali, did you want to make any comments on that? I mean, it's quite a process for all of us, and we do this for new products as well, or new screens that we want to offer. We look very, very carefully at what is permissible in a particular country. For example, we just started offering some exams in Australia, and we had to, get outside counsel's support and really look at that whole piece and what is permitted. So by virtue of the country law. So just like that particular product, we would do that for any screen if it evolved or changed. So do you want to make any additional comments on that, Anjali? Oftentimes
no,
you're on
agree. Yeah, exactly. I mean, we go through a process each time that compliance engine would be updated. So basically there's a legal review, a product review. It's a fairly lengthy process just depending on whether it's a new product or not. And, either internal or external legal review is conducted along with a privacy analysis as well. So, yeah, that's all I would add on that.
Yeah, I mean, the whole privacy piece of it is really important. I mean, that's why we have a DPO, a data protection officer. That's why we have on our team a team member who, although not an attorney, is a privacy expert with the particular designations necessary. And again, seeking outside counsel as needed, and our own internal team and our regional and local compliance officers are all really part of of this, along with our suppliers and along with our operations and implementation teams. So it's a team collaborating to do our very best to ensure compliance and that the engine is properly updated. I think you can move on probably to the next question, Anjali. Thank you.
Sure. So another question we received is, do you provide country data sheets so we know what is allowable?
Well, we provide a lot of white papers and blogs and information through our marketing team, and we also have monthly legislative updates available to our client subscribers. We have FADV e-newsletters, I think I mentioned the blogs, and webinars such as this to keep our folks up to date. So we do offer a lot of support regarding the particular country laws. Of course, we can't provide legal advice. We can provide compliance information and share what we know and share information that we get from our suppliers, from our internal team, from our outside counsel, and we strive to do that. Did I miss anything, Anjali or Matt, in terms of, I mean, we have meetings oftentimes with our clients as well to keep them up to date. And some clients I maintain a particular individual relationship with, and when I know there's a particular area of importance to them, that I'll update them just one-on-one. Other comments, Matt, on that piece? Or Anjali?
I think you've captured it well there. Thank you, Jo.
Thank you. Well, we only have a few more minutes, so I think we can take another question or so. Anjali?
Yeah, okay, so let's see. What does a typical global package contain?
I'd lob that to Matt.
If there is a typical.
That's a difficult one. A typical package would contain an education check, an employment check, a criminal check. If it's a financial organization, it may contain a credit check as well, usually a sanctions check of some kind, and often a media check as well. That would be a sort of basic package, and then they tend to go up from there with items like directorship checks. Organizations are now starting to look a bit more at things like social media checks, etc. But those are the typical ones we see in most packages. But also there are regulatory checks brought in as well at different country levels where there's regulatory requirements. But then obviously if you're working in places like the US, you then get drug checks and also fingerprint checks added into those packages as well.
Thanks, Matt. Okay, so we have about a minute. Let's see. Do either of you have a perspective on how customer companies typically handle compliance with various country laws. So have you seen a trend toward how that is handled? That could be a complex question potentially, but if you have any thoughts.
Well, from my perspective, I see a combined approach. I know that our clients depend on First Advantage for general compliance information. They also depend on their outside counsel and their internal counsel to support them. So I think it's pretty much a three-prong approach. Industry organizations as well is another way that we all get information from regarding global compliance requirements, including the NAPBS, which is becoming the National Association of Professional Background Screeners, that's becoming more and more global in nature as far as an organization is concerned. So I believe we all look to our internal resources, our external resources, as I already mentioned, that we rely in part on our suppliers. I think what's really important is an infrastructure, which is why I created the global compliance team when I took over global compliance at First Advantage a few years ago now. And that infrastructure really does help support compliance as long as if you have everybody watching is a good way to not overlook something. And so a local presence looking at compliance, even if that individual isn't particularly trained in compliance, it's still a very helpful way to keep track of changes in law. So I guess in short, what I see, and we're just about over time, is it's a combined collaborative approach that we all need to keep on top of the ever-changing global compliance landscape. And it's actually a pretty exciting thing to do. And again, our industry associations do help with that, including NAPBS and CBIA and some of the law firms that really focus on the compliance aspects of background screening. So I would say thank you all for joining us. And Shari, did you have any final remarks that you would like to make at this time? And we really appreciated your joining us, Matt, Anjali, myself, Shari, and thank you for spending the time, investing the time in listening to us for the last hour. And Shari, any comments in closure?
No further comments other than we will send out the continuing education credit hours shortly after this event, and my thank you as well. We'll turn the time back over to the operator.
Thank you all for attending. Currently on your screen there is a survey. We ask that you please fill this survey out for feedback purposes. Please note you may have to disable pop-up blockers on your web browser in order to see the survey. This concludes our webcast. Have a wonderful day.